One of the things that you'll see reflected in the white paper on the website for the summit, which if you have not read, I commend to you. It is largely the work product of my wonderful co-chair, Mark Nordenberg. But one of the things that is reflected in there is that indeed, love is the antidote to hate. But sometimes love needs a helping hand. And sometimes that helping hand comes through rule of law. And so for this particular panel, we are blessed to have people who are experts in rule of law, people who themselves have been victims of hate and have resolved to use their experience as a force for good, just as we are doing here. And so it is my great privilege to turn this over to my beloved Jones Day partner, Shirlethia Franklin, to introduce this panel.
Thank you. Good afternoon. Oh, come on. We can do better than that. Good afternoon. Thank you. That's more like it. As Laura mentioned, I am Shirlethia Franklin, a litigation partner in Jones Day's Washington office, and I am just thrilled to be here with you all this afternoon. And thank you all for welcoming us and joining us for today's Rule of Law panel, where we're going to be discussing a number of civil remedies to combat hate. And I don't think we could ask for a better group of ladies. We have maybe one of the first all-female panels. Each of these panelists has really been on the front lines of combating hate through a number of ways, through being victims of hate crimes, but also being true litigators and really at the forefront of addressing hate crimes through civil litigation. And as we noted here, and it's also in the white paper that Laura mentioned, we're going to talk about a number of legal theories today, as well as a number of ways that civil litigants can get involved in this work, even if it's completely outside of your field. There are a lot of partnership opportunities in the civil litigation space in combating hate crime. Now, I thought what we do before we delve into the discussion is to have each of our wonderful panelists just give a brief background of who they are and why they're here, and then we're going to come back and hear more about their stories and what they've done in this space. So we'll first start with you, Taylor.
Thank you so much. My name is Taylor Dumpson. I'm a hate crime survivor, a cyber harassment target, but I currently serve as a President's Fellow at the Lawyers Committee for Civil Rights Under Law.
Hi, I'm Taylor's colleague, Arusha Gordon. I'm the Associate Director of the James Byrd Jr. Center to Stop Hate at the Lawyers Committee for Civil Rights Under Law. It's a DC-based organization. We like our long names and our long titles, and I haven't come up with any snappy acronyms yet.
Thanks, Arusha. And Mary?
Yeah, I'm Mary McCord. I'm the Executive Director of the Institute for Constitutional Advocacy and Protection, and we have a snappy acronym, ICAP. At Georgetown Law, also a visiting professor there. And I came to ICAP, helped found it 4.5 years ago after a nearly quarter-century career at the Department of Justice.
Thank you, Mary. Amy?
I'm Amy Spitalnick. I'm the Executive Director of Integrity First for America, which is a civil rights nonprofit most known for supporting the plaintiffs in Sines v. Kessler, which is the federal lawsuit against the organizers of the Unite the Right violence, which goes to trial 1 week from today in Charlottesville. And before that, I worked in the New York Attorney General's office.
And last but certainly not least, Beth.
Hi, everybody. I'm Beth Littrell. I am a senior supervising attorney in the Special Litigation Practice Group of the Southern Poverty Law Center, SPLC. I'm a 20-year civil rights attorney doing impact litigation, started at the ACLU. Traveled to Lambda Legal, which is a national LGBTQ rights organization doing some anti-hate work, and then felt the calling to come to SPLC about 3 years ago to fight the rise of hate online and in real lives. Happy to be here.
Thank you, Beth. Now we're going to hear more about exactly why you all are here with us today. And Taylor, I thought we'd start with you. You know, so many of us were proud of you. We remember that day in April of 2017 when you were sworn in as the first Black woman student body president at American University. The first Black woman in 124 years, right?
Yes.
And just, yes, that deserves an applause. And as I told Taylor when I spoke with her last week, I was student body president, but I couldn't feel her shoes at all. I definitely didn't have the strength and the grace that you showed during that time. And I remember just one day after you were sworn in, you immediately became a target of hate. Can you take us back to May 2017 and tell us your story?
Yes, so thank you for having me. On my first day in office, May 1st, 2017, a mass perpetrator in the wee hours of the morning hung bananas from nooses around my predominantly white campus at American University. The bananas had references to the predominantly Black sorority, Alpha Kappa Alpha Sorority Incorporated, of which I am a proud member, and also had references, thank you, also had references to Harambe, the gorilla that was killed at the Cincinnati Zoo in 2016. As if the initial hate crime wasn't enough, within 4 days, Andrew England, the same neo-Nazi who cyber harassed Tanya Gersh, published an article on his website known as the Daily Stormer, encouraging his supporters to give me, quote, a warm welcome. In this article, Andrew England called me a nigger agitator, a nigress, and a she-boon. And he opened up what would become an onslaught of, the way I call it, is Pandora's box, just opened up online cyber harassment that continues to impact how I navigate my life on a day-to-day basis. That happened when I was a junior in college. So I spent the last year of my time at American walking past every single day where the bananas were hung from nooses. I was diagnosed with PTSD, depression, and anxiety, and I lost 20 pounds. I was like 120 pounds at the time, so I was like 100 pounds then. People don't always talk to you about how PTSD and living with that will change your life, but it's not something that just disappears. It's something that you have to keep going through every time. So Tanya mentioned earlier in the day how, her story is situated in a series of events. The same thing happens here. So just a few months after, maybe 6 months after Andrew England was targeting Tanya Gersh, he cyber harassed me. Within a few weeks after the cyber harassment against me was when Lieutenant Collins Richard III was killed on the campus of College Park. That's only a few months before Charlottesville happened. So luckily, I was able to have the great support of the Lawyers Committee for Civil Rights Under Law, a civil rights organization that I was an intern at the time, and they were able to pick up my litigation, and we were able to sue neo-Nazis in what would become the first time that a federal court found that online harassment could interfere with someone's use of public accommodations. And that's because I had to change how I navigated my time at American University every single day. So I didn't go and stay on campus super late. I wasn't walking back and forth, my classes and things like that. I would drive my car to campus. I would change how I would use the public transportation. I would change, how I just navigated on a daily basis. And so a lot of those things are what brought us, here, unfortunately, today. But there are definitely ways to fight back, and so civil litigation is just one of those ways to do that. And so we were able to use the DC Human Rights Act, which looks at public accommodations, which schools fall under as a protected place, which people cannot lawfully discriminate against you on the basis of race or sex in those categories.
That's an incredible story, Taylor, and thank you for sharing it. And doing this work now at the firm, we see that it's often hard to find folks who have been subjected to hate to want to relive that through litigation. So can you talk to us about what factored into your decision to be a lead plaintiff in impact litigation?
Yes, much like Tanya was speaking about earlier, I couldn't imagine that happening to somebody else. I was 21 years old at the time. I'm 25 now. But looking back, I was just a 21-year-old kid, and all of a sudden, neo-Nazis wanted me dead. It wasn't something that I expected. It wasn't something that I asked for. It just sort of happened to me. And so I wanted to make sure that while I was on campus at AU and, while I understood the unique intersections that my story had with online harassment, actual physical hate crimes on campus, cyber harassment, race and gender motivated violence there, I knew that my story had the potential to impact a lot of different people, and so I didn't want it to happen to anybody else. So I decided, well, if it had to happen to somebody, it happened to me, but I happen to have the resources and the connections to be able to do something with it. And so I, as an intern, was sitting down, I was like, I went into my supervisor's office, I said, can we sue neo-Nazis? Like, is that something we can do? I had never, I hadn't really thought about it, I wasn't really sure. But that was because the individual who hung the bananas from nooses on campus was never identified. So that ended up being a cold case that the FBI, the Department of Justice, and the Metropolitan Police Department were unable to identify that person. And so it was only because there was no one else for me to possibly envision holding accountable that I even thought, how do we use the law to sue people who cyber harass me? Because I knew that just couldn't be lawful.
And was this experience, as horrific as it was, a motivating factor in your deciding to become a lawyer yourself?
Ironically, no. And I say it like that because my experience as a Black woman and as a Black girl was actually what did it. I was a year younger than Trayvon Martin when he was killed by, Zimmerman. And I was watching that as a 15-year-old and seeing somebody that looked like me, somebody that could have been my classmate, killed by a white vigilante. And I said, I want to be just like the lawyers that are representing, the Martin family. I was like, I want to be one of those people. And so that was the first time I considered using the law as, in the civil rights space. So when I actually got to American, I was already a law and society major, and I was already planning to go to law school. But that was the impetus for me going straight through law school and going straight from graduating, going straight to law school, and now being on the fighting end.
Wow. And as much as we hope that others don't have to experience this, we know that these things continue to happen even as we sit here today. So what message would you like to send to others who might find themselves in your shoes, or even lawyers who want to get involved in this work?
It might be scary, and it might seem like a really daunting, task to try and fix, but it really requires everybody to do their part and to lean into discomfort. And when you see something, really to be able to say something and really to hold folks in our communities and our allies accountable. I mean, it is really difficult sometimes to be brave and to have that kind of courage to go out into these spaces and to fight back like that. But without each of us doing our jobs, it's not going to crumble.
Well, thank you so much, Taylor. We applaud you for your strength and your grace and just your bravery. Thank you. Okay, can we now pass the clicker over to Arusha? Arusha, and can we bring up the PowerPoint presentation for Arusha? Thank you. And Arusha, it's fitting that you're sitting here right next to Taylor, because we know that you and the Lawyers Committee for Civil Rights Under Law were so instrumental in the successes that we saw in Taylor's case. So why don't you just first start by telling us a little bit about your work through the James Byrd Center to Stop Hate.
And first of all, it's always such an honor to share the stage with Taylor and other folks who have shared their very personal stories about experiencing hate. This work isn't easy. It doesn't necessarily pay that well, if at all. And it's hearing the stories and seeing the fire that so many people bring to this fight that keeps me going, even when I'm tired. So thank you. So let's click this over. The James Byrd Jr. Center to Stop Hate was formed in 2017 after the Trump election, with the mission to support individuals and communities targeted for hate to combat white supremacy. And we do that through using litigation and other legal advocacy, as well as some policy work and lots of education. We have a pretty robust training program that has trained nearly 1,500 police officers on how to work with communities experiencing hate. Just quickly, I feel like one of the speakers might have mentioned him, but I'm kind of curious who here, if you can raise your hand, who here knows who James Byrd Jr. is? Okay. So not an overwhelming amount, but actually more than I usually see. And I just always like to ask that question and say his name because he was a victim of a hate crime, a really horrendous hate crime in 1998 in Jasper, Texas. It was incredibly gruesome. It shocked the nation. It led to some of our most important hate crimes legislation in the country. And we are so honored to do this work in partnership with his family, as well as other survivors of hate. So I just like to take a moment and recognize James Byrd Jr. So I know we all just ate lunch. Getting into the nitty-gritty of legal strategy is not a great way to stay awake, even if you're a legal nerd, like I think I'm gonna just say all of us up here are. So I'm not gonna go too much into the weeds. Taylor already talked about her case, so I'm not gonna recount the facts. But I did want to kind of just mention some of the legal strategies we've used in her case, as well as some of our other cases. So in the case against Andrew Anglin, as well as some of the other online harassers, as Taylor mentioned, we used the DC Human Rights Act and got a judgment that set some precedent in the online hate arena, which was very exciting. We also used the DC Bias-Related Crimes Act, which I imagine most folks here know that most states, but not all, have hate crime laws, which are really a key tool for government prosecutors to hold perpetrators accountable. In some of those laws, there are also civil provisions that allow individuals like Taylor and others to then bring their own suits, their civil suits. So we brought a claim under both of those statutes in DC, and we also brought tort law. So actually, another quick poll, how many folks here are lawyers? Or like legally trained, I guess. Okay, so I'm not gonna be too legal-easy. Tort law, for those who don't know, because I don't know if I knew before I went to law school, is kind of akin to personal injury law. The remedy you're really seeking is monetary damages, which I just like to emphasize because, as Taylor was mentioning, hate crimes can sometimes have physical impact, but they almost always have really, really significant emotional and mental impact. And that impact lasts weeks, months, years, decades. So, you know, getting money for therapy, which is very expensive in our country, especially, you know, getting good therapists, not always covered by insurance. It's important. And so we do have some tort claims in there. And Taylor didn't mention it, but like it's one of my favorite things about the case is we had 3 defendants. We got a default judgment against 2 of them. Taylor also led the process and had the idea to do a settlement with the 3rd defendant. And that was really, really, I think, of all my years of practice, is one of the most exciting things I've done. It's not every day you get to sit down with a white supremacist and ask him to take classes on the history of racism and sexism in our country. And Taylor, again, just led the process with such grace and creativity, I would say. So. More recently, we also brought a suit against the Proud Boys. This is coming from, in the wake of the last election, a bunch of Stop the Steal rallies. One of them was in DC on December 12th. During that rally, there was a bunch of street violence. There were a series of churches that were displaying Black Lives Matter signs that were targeted. Our client is the Metropolitan AME Church, which is a historic Black church in downtown DC. It's actually the longest Black-owned piece of property in the District of Columbia. And they've had congregants such as Frederick Douglass, and they've also had Rosa Parks and Barack Obama, worship there. So really exciting to be working with them. But yeah, they had Proud Boys trespass, vandalize their property. And so we worked with them to file suit on January 4th, 2 days before the attack on the Capitol. Again, we brought claims under the DC hate crimes law using the civil provision. We also brought torts. And then we brought a claim under the FACE Act, which is not about your own face, but it's actually let me see if I can get this right, the Freedom of Access to Clinical Entrances Act, which is actually about providing women with access to abortion. So you might be like, what the heck does that have to do with this? So in 1994, when the act was passed, there was a congressional compromise. I guess that was when Congress still compromised. So they included language about also protecting rights to religious worship. And so we used that language to include a claim under the FACE Act. And it's pretty exciting because there's not that many claims under this provision. So yeah. Before I go on, I also just wanted to pause because you'll see the seeking information flyer up here. We sued the Proud Boys as well as their founder, as well as a number of John Does. And so we are actively seeking information. And I figured this is an audience that has a lot of researchers. So if anyone recognizes their neighbor in the picture, or anyone else, please reach out to me. The full video of the attack, as well as other pictures, screenshots, are available on our website, and we have a tip line, or you can just find me. But yeah, I did want to take that opportunity. And just briefly, I'm not going to go into all of these, but just a quick bullet point of other types of legal strategies we sometimes consider. A lot of the cases we hear about involve neighbor-on-neighbor harassment, and so one of the first things I often look at are like state Fair Housing Act claims to see if there's something there we can work with. We also use the KKK Act, which I know Mary and Amy are going to talk more about, but we brought a suit recently against the Proud Boys and Oath Keepers concerning January 6th, where we have a KKK Act claim. And then I also just wanted to share, sometimes it doesn't make sense to sue in federal or state courts. We also get creative and have brought claims in other bodies. So for instance, last year, we brought a claim in the New York City Human Rights Commission about some tenant-on-tenant racist harassment. And finally, sometimes we don't bring the cases ourselves. We look to our partners who have brought great cases and who we want to support, and we'll file third-party briefs called amicus briefs. And actually, the first matter my project ever worked on was with Jones Day in 2017, I believe. And it was an amicus brief regarding some online harassment out in high school in Northern California. A bunch of white boys in the school created Instagram accounts that really viciously mocked and harassed the girls in their class, the girls of color in their class. And it included just horrific content. So pictures of nooses around their classmates' necks, comparing their female classmates to gorillas, just horrific stuff. And so when these Instagram accounts came to light, the school tried to take action in a little bit of a messy fashion, ended up disciplining the boys, and then the boys turned around and sued the school. And all of a sudden, we just saw this conversation that left the girls out. It was about, does a like on Instagram constitute free speech? Like, what did the school do? And so we brought this amicus brief to really tell about the impact of online hate on these young women. And we also talked about Title VI and Title IX obligations, as well as some of the First Amendment case law. But that was in conjunction with Jones Day, so I always have a soft spot for Jones Day, and was excited to join today.
Thank you, Arusha. And I mentioned at the top of this panel that there are ways for lawyers to get involved and partner with organizations like Lawyers Committee. Can you just talk briefly about that for those who might be interested?
Yeah, we partner in almost all our cases with large pro bono firms, large firms who do the work pro bono, I should say. So Jones Day, Paul Weiss, Kirkland Ellis, lots of them have come and fought the fight with us and bring resources that as a nonprofit we don't necessarily have.
Thank you. All right, well, Mary, we're gonna turn it over to you next. Mary and I were colleagues at the Department of Justice, and I know you have spent many years working on these issues, and you mentioned the work that you do now at ICAP. So can you tell us about the legal issues and cases that you've seen through that work?
Sure, of course, and really inspiring to listen to Taylor's story. First time I got to hear the whole thing straight from her. I appreciate her sharing that, and also the other victims that have shared their stories today. So we stood up ICAP to bring constitutional impact litigation across a range of issue areas, and this was in the summer of 2017. I and several colleagues, 6 of the 10 of us attorneys, we weren't even 10 at the time, we were just a few, but ultimately became 10 attorneys. 6 came from the Department of Justice. So we wanted to tackle a number of public interest areas from outside the government rather than from inside. So that included cash bail reform and immigration issues and First Amendment issues. But then right days after we filed our first brief in a cash bail reform case, Unite the Right happened. So on the Friday night, of course, we had the Tiki Torch March through the campus of the University of Virginia, where my son was a rising third-year student. On the Saturday, we had the open-air street battles between white supremacist groups that marched through the city with shields and flagpoles that were pointed on one end, and bats, batons, clubs, helmets, flying their banners, chanting, "Jews will not replace us," "blood and soil," etc. And at the same time, we saw that there were self-professed militias dressed head to toe in military kits with their helmets and their flak jackets and their combat boots and their AR-15s and their extra magazines of ammunition and their additional sidearms, interposing themselves ostensibly between the white nationalist protesters, who, by the way, claimed that this rally was in order to protest the city's decision to take down Confederate memorials, the memorials of Robert E. Lee and Stonewall Jackson. And so this was about a protest against that decision that coincided with a lawsuit, which only recently was finally resolved, and those statutes came down about a month ago, I'm happy to say. So these militias, they claimed that they were not themselves white supremacists, they were just there to protect the First Amendment rights of the white nationalist protesters, but they physically interposed themselves between the protesters and counter-protesters, you know, asserting authority over others that they didn't have, of course, with their hands on their AR-15s. And as this devolved into street battles, the white supremacist groups against the counter-protesters with violence and throwing, you know, newspaper boxes and anything they could find at each other, and using their pointed pole arms and their shields as phalanxes, you know, actually looking back to ancient history. They had planned this in advance. You know, I sort of watched on television and I heard commenters sort of kind of throwing their hands up. Well, they've got a First Amendment right to be there. Remember Skokie, and these militia members, they have a Second Amendment right to have their firearms. Sort of a little bit defeatist, like what can be done? And we were this brand new organization, and I had just left the Department of Justice, where I'd been the acting assistant attorney for national security, and before that a prosecutor for about 20 years, and I thought, well, the First Amendment doesn't protect violence. It doesn't protect incitement to imminent violence or imminent lawless activity. The Second Amendment, the Supreme Court's been very clear, protects an individual right to bear arms for one's own self-defense. It doesn't allow you to be your own private army and go out there and you know, order others around at gunpoint. There must be something we can do about this. And the one thing that was different about our litigation from the other litigation that you're hearing about from my fellow panelists is we came at this thinking about what do we do to prevent this from happening again? What could we do is a way of litigating that would get some sort of court orders that would prohibit a repeat of Charlottesville. Because as you may recall, that very night of the rally, that Saturday night, Jason Kessler, Eli Mosley, the other organizers were already saying that they were going to be coming back again and again because their civil rights, my microphone's right there, sorry. Their civil rights were violated when the law enforcement had declared an unlawful assembly, you know, in the middle of what they had hoped to be this rally that allowed them to step out of the virtual space and into the physical space and prove to the world that they were more than just a meme. So we got to thinking, what could we do to run into court and prevent that from happening again? And it just so happened that I went on to a blog post called Lawfare, which some of you may be familiar with, and I went on that in order to actually write about the fact that James Fields, who rammed his car into the counter-protesters after the rally had already been declared an unlawful assembly, he rammed his car into counter-protesters, killing Heather Heyer and tragically injuring dozens of other people. And Amy will talk a little bit more about some of those injuries and the litigation involving that. But I went on this blog site to write about the fact that he was a domestic terrorist and he should be treated like one. But while I was there, I saw the work of Philip Zelikow, who talked about state anti-militia laws that the Southern Poverty Law Center had used back in the 1980s to bring civil litigation against the militia wing of the KKK to seek injunctive relief. And literally I said, bing, 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 that's our ticket. I called Philip Zelikow. I went and met with him the next week. And we brought our case against 23 different white nationalist organizations and the self-professed militias and their organizers, not seeking damages. That's what the case Amy's going to talk about is about, seeking only forward-looking relief to get court orders to prevent them from coming back, organizing themselves in engaging in paramilitary activity against others. So the idea was, it was entirely a content-neutral litigation, right? It was based on bans against engaging in paramilitary activity. It was based on the constitutional prohibition on private militias in Virginia and 48 states, all but 2 have a constitutional prohibition. And it was banned on the state law that prohibits you from falsely assuming the functions of law enforcement, like some of these militias did. And so we brought this case on behalf of the city of Charlottesville, local small businesses, and local residential communities. And what we found, and you'll hear more about this from Amy, I'm sure as well, is that everything you saw that day in Charlottesville, it was pre-planned. This was never about a free speech rally to protest taking down those Confederate monuments. The planning from the beginning, as I mentioned, was to get out of that virtual space into that physical space and really flex the muscle of the white nationalists. So we were aided in our work by a group that essentially either hacked into or somehow obtained all of the planning communications that were done over Discord, which is a platform that has been used by gamers, but was used by those who planned the Unite the Right rally. And it showed very clearly how they engaged together, planning to, in their words, crack some commie skulls. It was their plan to be provocative enough that counter-protesters would throw that first water bottle or that first punch, and then they would respond, tenfold, 100-fold with violence, and then invoke self-defense. So that was their strategy, provoke and invoke. And you could see it now, when you look back over at the video and you look back at the photos, that's exactly what those white nationalist groups were doing, organizing themselves as armies. And they sent sorties out of the park, literally in waves, to go engage with counter-protesters, come back into the park and get their eyes cleaned out from mace and other chemical irritants, and steel themselves to go out and have another skirmish. So our case, was novel in the sense that it had some precedent in 2 published cases from the 1980s, but nothing quite as novel as this. That this was in state court. We brought our case directly under the state constitution, under state criminal laws. It was a civil suit, so we had to find a way to make an argument that we could bring a civil cause of action even under a criminal law. And so partly we did that by relying also on the law of public nuisance. And we were successful in, the court ruled against a motion to dismiss. He ruled in the favor of the city and all of our plaintiffs on every cause of action. Each one he allowed to go through. And at that point, of course, the remaining defendants, some had already agreed to a consent decree to get out of the case because they didn't want to come back to Charlottesville again. But the remaining defendants realized going to trial at this point for them was pointless because we had video, we had audio, we had photos, we had witnesses that would say what happened. And once they lost on the legal theories, there wasn't all that much more to fight about. So we were actually ultimately able to resolve that case a few weeks before the 1-year anniversary, at which time the organizer, Jason Kessler, had planned a Unite the Right 2.0 in Charlottesville. And so just a few weeks before that, we were able to reach a resolution whereby every single one of the defendants and their organizations and their successor organizations agreed permanently not to return to Charlottesville as part of a unit of 2 or more persons acting in concert while armed with anything that could be used as a weapon during any protest, rally, demonstration, or march. And one of the things that was important about this case is not just that it established some precedent for additional cases, and in fact we are right now co-counsel with the elected district attorney in Albuquerque, New Mexico, in a case against the New Mexico Civil Guard, a private militia there that deployed last summer during racial justice protests, heavily armed, full military kits, intimidating people from exercising their civil rights, their First Amendment rights, by having their weapons and ordering people around, resulting in a shooting. Not only have we used it for that litigation, which I will say we just actually survived a motion to dismiss there as well, a judge similar to in Charlottesville, ruling in our favor on every single cause of action. So we now have 2 state court judges in 2 states that have done the same. But beyond litigation, we've used these anti-militia state laws to help cities and local jurisdictions and activists put pressure on their cities to engage in content-neutral time, place, and manner restrictions on hateful marches and other types of protests that are expected to result in violence. So for example, we will get a call from a city attorney saying, the KKK is coming next week for a White Lives Matter march. We don't want to be another Charlottesville. What can we do? And we can use this legal precedent as a way for them to say, okay, well, we are going to prevent weapons. We are going to prevent people from coming in with flagpoles. We're going to have a stadium environment where protesters and counter-protesters come in to different areas and are separated by a buffer zone to try to protect public safety. We've also used these state laws as a basis for policy work last year, right? Getting the word out far and wide through all kinds of public education and fact sheets that private militias are unlawful, and if you see them at polling places or in demonstrations, that's not okay, that's unlawful. At polling places, it would be voter intimidation. Voter intimidation isn't protected by the First Amendment. Private armies aren't protected by the Second Amendment. So there's much work to be done here. It's been also the basis for proposing I testified about some proposed federal legislation this spring that Congressmember Jamie Raskin is working on with us right now, and hopefully a way, and if you're interested more to learn about private militias, there'll be a panel on this tomorrow. But I think important in all of this is First Amendment. It's one of the things that makes this country great and separates us from authoritarian countries, but it is not boundless. And when we're talking about hate speech and cyber harassment and violence during protests and demonstrations and threats to election officials, to public health officials, to school board members, that is not protected First Amendment activity.
Absolutely. Thank you. Thank you very much, Mary. I was so excited about this panel for a number of reasons, including the dynamic panelists we have, but there's so many incredible overlapping themes and the natural synergies that we're seeing among each panelist. And Amy, I know you and Mary share, and as do I and the Jones Day team, the work in Charlottesville, and many of us remember far too well the events that took place in Charlottesville in August of 2017. And Mary just talked about that case from the perspective of the state litigation that ICAP participated in, but would be very interested in hearing your take on the federal lawsuit that you brought with your organization with Integrity for First America, and talk to us through that lens of Charlottesville.
Absolutely, and thank you so much. And Taylor, it's so wonderful to be with you on this panel and hear your story. And I think particularly Mary and I have been on the panel circuit together probably quite some time. And it's always so wonderful because I feel like our work is so complementary. And these 2 cases really look at 2 specific legal options to take on extremists in the aftermath of something like Unite the Right. I think to step back, it's so clear that there has generally been a stunning lack of accountability when it comes to extremism in this country. No one looking at the cycle of violence over the last few years can say that those responsible have faced any semblance of true accountability, and those impacted have gotten the justice that they deserve. And so that really is our goal with this lawsuit, much like it is for all of my fellow panelists, to make sure that we are, however possible, within the bounds of the laws that we do have, making clear that there will be consequences for participating in this sort of hate and violence. And so that really is our goal at Integrity First for America with this case. And when we go to trial 1 week from today, that is what we intend to show in court. To back up, and some of this echoes what you heard from Mary, what happened in Charlottesville wasn't an accident. That violence was planned meticulously in advance in the Discord chats that Mary mentioned, and a number of other forms of communication over the last, in the months leading up to Unite the Right. And in fact, in this case, we've collected 5.3 terabytes or 5.3 million megabytes of digital evidence, illustrating that extent of the planning that went into this, well beyond the Discord chats that were leaked out into the world by Unicorn Riot in the immediate aftermath. And in those chats, as Mary began to describe, they discussed every details down to how they intended for there to be violence, cracking commie skulls, and whether they could even hit protesters with cars and then claim self-defense. And there's a horrific meme called the John Deere Protester Digester alongside commentary of how they intended to hit protesters and speculating about what might be considered self-defense under various state laws. So that's not an accident. That's not a clash between two opposing sides, as many of these defendants will try to make it out to be. That's a racially motivated, violent conspiracy, and we have laws that are meant to protect against that. We mentioned the KKK Act earlier, and it is that exact statute that's at the centerpiece of our case. The Ku Klux Klan Act is 150 years old, passed by the Reconstructionist Congress, signed by President Ulysses Grant, and somehow in the year 2021, it is having a renaissance because we are living in this sad moment where violent white supremacy is renewed and rearing a very ugly head that deserves to face accountability. And so we are going back to this 150-year-old statute, in our case, to hold those responsible accountable. Our plaintiffs are 9 Charlottesville community members who were injured in the violence. Many of you remember the tiki torch violence. Some of our plaintiffs were surrounded at the Thomas Jefferson statue on UVA's grounds, where they were kicked, punched, beaten, had fuel and lit torches thrown at them. One of our plaintiffs, who was a black undergraduate at the university at the time, said he thought he was going to die. The next day, of course, we know about the car attack that killed Heather Heyer and injured so many others, including a number of our plaintiffs. And if you know that iconic Pulitzer-winning photo of the car going through the crowd, you see our plaintiffs like Marcus Martin, who's sprawled across the back of the car, Thomas Baker, who's flipping over the hood of the car, and folks like Natalie Romero, whose skull was fractured in the attack. All of our plaintiffs were grievously injured, not just physically, but as Taylor and others have alluded to, emotionally, psychologically, and the impacts of surviving something like that are just unfathomable, I think. And the goal here is to hold those accountable responsible for this conspiracy. The Ku Klux Klan Act was designed specifically to protect against this very sort of conduct, racially motivated violence that targets people based on their race, their religion, and their willingness to defend the rights of others. And it specifically includes not just racism, but anti-Semitism, which case law has made clear, and similarly, the supporters of those people, supporters of racial and religious minorities. And so our defendants are a who's who of this movement, names that have come up frequently today over the course of this conference and this panel. Richard Spencer, Andrew Anglin, of course, and his LLC, groups like League of the South, National Socialist Movement, 24 altogether, about half individuals and half groups. And the goal here is really a simple one. It's, of course, to win justice for our plaintiffs, to hold accountable those responsible, but we know that civil litigation can have impacts that extend well beyond this. We know civil litigation can and has throughout history, cases, including the ones we've talked about here, and cases brought historically by the SPLC, for example, have effectively bankrupted and dismantled a number of these hate groups. And that is what we're already seeing in this case. There was a story in USA Today today about how many of our defendants are already really feeling the financial and operational pressure as a result of this case. And when we go to trial and hope to win large financial judgments from a jury, we can really effectively bankrupt, disrupt, and dismantle these groups and these leaders and make clear the consequences for this hate. Trial will be 4 weeks, starting a week from today, and I think there's also power in that. Having a trial where the community of Charlottesville and the broader surrounding area can finally hold accountable those who attacked their community. Our plaintiffs can testify to the horrors that they survived, and the defendants can be put on the stand and examined and presented with this extensive evidence that details exactly the hate and the violence that was at the core of what they orchestrated 4 years ago. So I know that we are eager to get to court 4 years later. I don't think any of us on this panel would suggest that the civil justice system works fast, quickly in this country. 4 years later, we are finally going to trial. And I think it will be a powerful moment to really illustrate not just the accountability that's crucial here, but hopefully serve as a deterrent to others and a model for how you can use this sort of litigation to seek that accountability and to finally win semblance of justice for those impacted.
Absolutely, and thank you so much, and thank you, Mary and Beth. I know we're going to turn to you shortly for the work that you're doing. This is all bringing back flashbacks. I remember, and I think my colleague Barbara Hardin is in the audience, we represented 4 of the 5 city councilors in Charlottesville who were sued as a result of voting to take down the Confederate statues. And there were many of times where we would trek to Charlottesville and get ready to do a hearing, and I, being the only African-American woman on the team, would be greeted with a Confederate flag walking into the courtroom. But little did they know that this country girl from the Mississippi Delta had probably seen that flag more times than I want to see it. And it just gave me ammunition to go in court and really kick their butts. Sorry for my language, but but it does, the work you're doing just stresses the importance of continuing to fight, because it shouldn't become normal, right, to see these symbols of hate. So thank you so much. Well, Beth, we know that the Southern Poverty Law Center has, for decades, been a longstanding player and leader in fighting hate crimes across this country. So why don't you just start by telling us just generally about your work at SPLC and some of the cases and issues you have worked on there. And I know we're going to talk about the Gersh case, but just generally tell us about your work.
Well, so it's an honor, a privilege to be up here with all these, this sort of brain trust, and thanks for all the shout outs to SPLC sort of legacy work. I would call it legacy litigation in the sense that SPLC in the 80s and 90s really created and crafted and litigation strategies to hold accountable groups, hate groups, and terrorists who were causing enormous harm based on their sort of racist ideas. So I think it's literally true to say that SPLC sued the Klan almost out of existence. They're back. But the challenge today is that instead of white hoods in barns, around burning crosses in the Deep South, the hoods are pseudonyms online, and they don't own property that we can seize in the same way that we were able to seize their property and unmask them and identify them. So it's a whole new world and a whole new challenge, and SPLC is ready to take it on. One of the things that I'm hoping to do at this conference, this summit, is to suggest that we can't do this alone. I know that there are a lot of organizations doing this, but we need an army of litigators. We need to be thoughtful, we need to be coordinated, we need to have policy ideas, because the laws that we're using are, we're doing the best we can. We're coming up with some really creative solutions, but they're not really meant to hold people accountable in the same way. We're doing it, but they're sort of outdated, and the courts are trying to catch up. And I think it's our charge to help them understand and apply the laws that do exist for this age, in which online hate and online speech should not get any protection from the First Amendment. And we should be sort of at the vanguard of that. And so my colleague Scott McCoy, he is the Deputy Legal Director of the practice group, the Special Litigation Practice Group. He's here amongst us. If you see him, if you see me, let's talk about how we can seed, support, and otherwise collaborate, because it's a whack-a-mole approach right now. We've talked about, I mean, we'll talk a little bit about Gersh if we have time, and the successful litigation that we had there. But we need, this is happening so frequently. Taylor was courageous enough to come forward, had the resources, and Tanya found us, or we found her and had the resources. But there are scores of people, and we've heard some comments about the public officials, the public health officials, the teachers who are brave enough to teach history, right? To teach race and the history of this country, and they are being targeted in a very similar way to the way that Tanya, the way that Taylor, and they are, quitting their jobs and otherwise being harassed and terrorized. And it's going to take a lot of us, and we need to get on it. So.
Thank you, Beth.
Yeah.
And I know Tanya is at least at the conference, but I'm not sure if she's here today. So, and when you hear about these cases, you often hear about Taylor and Tanya. And so we've heard about Taylor's case on the panel today. Can you tell us about the Gersh case and your role in that, and anything that would be helpful for folks to know about that?
Absolutely. Tanya, you all heard her, hopefully you all heard her speak earlier so eloquently about the harm, the impact of what happened. Let me tell you a little bit about how that unfolded. So Tanya is a real estate agent. Like she said, she's a mom. She's in this small town of Whitefish, Montana. And there's kind of a bit of a playbook, I think, that sort of unfolded here, in the sense that she unfortunately came into contact with Richard Spencer. He's the Trump, hail victory, with his straight arm toast after Trump won, and met with straight arm salutes back. His mom lived in Whitefish, Montana. He and his mom bought a building that they renovated together. There was 2 commercial spaces and 2 Airbnbs. He had apparently taken his name off of that property, but he was associated with that building. And after that video went viral, there was Facebook comments from this little town saying, all right, this is it, enough is enough. We should do something about, to ensure that people know we don't associate with this kind of neo-Nazism. And so there was talk of protesting that building, and Tanya, sweet-hearted woman that she is, knew the commercial tenants and gave them a call and said, there might be a protest of your building. Be careful, put a Love Lives Here sign, or, things could get ugly. And one of the tenants said, well, Sherry Spencer, the mom, is a lovely lady. Some deposition testimony that, I think contradicts that, setting that aside. If she was, what do you think she should do? Tanya said, well, if I were her, if it were my son, here's what I would do. I'd sell the building. I'd give some of the proceeds, the profits, to a local human rights community, and I'd sort of, put out a public statement. What a great idea. Can Sherry talk to you? Would it be okay? Can I give her your number? Or will you call her? She said, she can call me. I'm not going to call her. So Sherry Spencer calls Tanya. Tanya gives her the advice, and she asks her, will you be my real estate agent? She says yes. So that's the truth of what happened. Here's the twist of what happened. Richard Spencer's posing as his mother writes a Medium blog. So Medium, anybody can write a blog. So he pretends to be Sherry Spencer. He says, I'm Sherry Spencer's mother. Tanya Gersh targeted me and tried to, terrible threats against me. Her name is Tanya Gersh. And so he tweets out, pretending to be his mom. This is what my mom wrote. Tweets it out to the right-wing echo, chamber. Immediately picked up by the horribles, the deplorables. I'm going to call them the deplorables. I'm going to go ahead and say it. Me and Hillary, we're calling deplorable a deplorable. And Andrew Anglin was one of those. He's got this vicious. There's just no other way. I've never seen anything like this in my life. I cannot describe to you how disgusting, vicious, and vile this website is. And it masquerades as a paper, I guess, a newspaper. So that was sort of the interesting. The lawyer interesting pieces were involved in convincing the court he doesn't get reporter's privilege. He's not a reporter. All he does is comment on other articles, which are usually just blog posts like Medium. So the twist was Richard Spencer. The twist on the twist is Andrew Anglin posting headlines like Jewish racketeer criminal cartel extorting Richard Spencer's mother. So right now it's a Jewish conspiracy. And unless you think that this is not somehow this is just political speech, which is what he tried to claim in court. I mean, the first of 30 articles, so he wanted to ensure that the message got out. He published Tanya's contact information, her husband's contact information, business, personal, every way that they could contact him, her, their son, his YouTube or his, any other social media opportunities. It gave the number to the Professional Licensing Board, to the Bar Association, suggested that they contact them. And then the disclaimer, here's the playbook. The disclaimer is now, remember, no threats, people. Keep it cute. And then tried to hide behind the fact that I didn't do anything. I just published public information and suggested that maybe they stop by their house and tell them that you're quote unquote sickened by their Jew agenda. And so that's the sort of backstory. That's the facts that brought us together with Tanya Gersh. We sued in federal court under diversity jurisdiction because he lived in Ohio, or we believed he was a resident of Ohio. He's on the run now, so that's at least something. He apparently is out unwelcome in the United States at present. But we sued under state tort theories. You heard the word tort up here before: intentional infliction of emotional distress, invasion of privacy. And Montana has an anti-intimidation statute that was helpful, that we brought as well. And so I think what set this case a little apart was that he actually defended this case. There was default judgments, meaning he didn't even show up, and so they got default judgments against him. He hired a self-proclaimed First Amendment lawyer and filed a motion to dismiss and said, protected by free speech. And we got a really great decision out of the district court in Montana that said, this is, number one, this is not a matter of public concern, this is a private vendetta. And you can't hide behind the fact that it's anti-Semitic speech to say that this is political. Now, what I wanted to have happen was the court to agree that this is the kind of speech that's unprotected. And I know that's unpopular. I told you I started at the ACLU. I know there are, First Amendment purists out there. I used to be one, but there are categories of speech like incitement to violence, like child pornography, that there can be, especially now when we see the results of this. I would like to see a body of law that starts to recognize that there is no place, online or otherwise, for this kind of vitriol that leads to violence, and including because some of the hate groups that SPLC tracks and knows about, they advocate a race war. They advocate taking down the system. This is dangerous, dangerous speech, but then they say, oh, there's nothing imminent. I didn't tell anybody to burn anything down tomorrow because that's what the law says today. So we didn't get the unprotected speech. We're still trying, but we did get the court to recognize that this was, when you provide substantial assistance, which is what he did, to the harms that followed, you can be held accountable. We had an evidentiary hearing after he did not show up for his deposition, and the court denied. He tried to claim that he couldn't come to the States because the SPLC is the hate group, and he was afraid for his own life. The court said, show up at your deposition. He didn't. That's when we got our default judgment. But we had the opportunity to, as you say, put on, not exactly trial, but we were able to present the evidence of what he had done, the harm that it had caused, and we received in compensatory damages based on the lost both medical bills that had been paid and lost wages because Tanya couldn't put her sign. She was a very successful real estate agent, but she couldn't have any listings. Her husband's business had to close down for days at a time, right? So that was $4 million because future lost earnings, $4 million plus, and then a $10 million punitive damage award. So we got this huge damage award. We are trying to collect on it because cyber currency, digital currency, is very difficult to get your hands on, but we're working on it. We're going to be I'm going to be listening very intently to all the panelists about cryptocurrency, because that's how they are, it's where they've moved their money in order to keep the victims from getting their hands on it. But nonetheless, we're going after them. So I hope you heard me at the top of the message. Come see me, come see Scott. We really need to all work together to figure out how to make this happen.
Thank you so much, Beth. And your top of the message point is a great way to wrap up the panel. As Beth said, we need an army to do this work. And our charge to you is to enlist and join that army. You don't have to be a civil rights expert, nor do you have to be a constitutional scholar to do this work. All you have to have are the interest, the will, the time, and the heart to care. So I ask each of you to join this army and to join me one last time in thanking many of our leaders of this army. Thank you all so much.